Welcome to today's Explainer. I am seriously thrilled you're joining me because we're about to explore a genuinely fascinating legal journey. We're looking at exactly how traditional Indian intellectual property law has been uniquely and sometimes creatively adapted for the wild digital frontier of cyberspace. We aren't just talking about abstract, high-level concepts here. We are going in-depth into the rigorous, structural ways a highly codified legal system stretches, bends, and evolves to govern the internet.
Okay, let's dive right into this. Our roadmap today is broken down into four key areas: cyberspace and IP rights, software as literary copyright, domain names and cybersquatting, and finally, patenting computer-related inventions.
Starting off with Section 1, Cyberspace and IP Rights, the theme of adaptation. And moving right into Section 2, Software as Literary Copyright. Well, before we hit the exact statutes, the overarching story you need to understand is that when the internet completely exploded, India didn't just toss out the old rulebook. Instead, they managed this bizarre new digital reality through deliberate legislative inclusion and some incredibly creative judicial gap filling. A perfect example? Look at how the Indian Copyright Act of 1957 was updated. Through a major amendment in 1994, the act explicitly brought computer programs under the definition of a literary work. Instead of creating a wholly separate, brand new regime just for software, the legislature decided, hey, source code should be protected exactly like a novel. Think about that for a second. Legally speaking, a string of C++ instructions causing a microprocessor to calculate data is treated with the exact same foundational copyright logic as a poem. It's just a fascinating conceptual leap. So the absolutely crucial point here, and this is a big one, is understanding the idea-expression dichotomy. Copyright only protects the literal code you type out, right? The expression itself. It does not protect what the software actually does, the underlying algorithm or the functional idea. To put it practically, if someone rewrites your entire app from scratch in a completely different programming language, and they don't copy your literal code, copyright is not going to help you. That functional core is entirely the domain of patent law. These two laws are not alternatives you choose between. They protect genuinely different aspects of the exact same underlying software. Now, because software obviously isn't functionally the same as a standard paperback book, Section 14B of the Copyright Act steps in to grant owners a unique, highly specific right, the exclusive right to sell or give on commercial rental copies of the program. This right isn't just automatically available for regular literary works. But for software, this is the specific statutory hook that powers India's entire software piracy enforcement regime. Unauthorized commercial rental or distribution isn't just a minor afterthought. It is a distinct, independently actionable infringement under the law. It's a real game changer for enforcement.
Section 3, domain names and cybersquatting.
Moving to our second pillar, we're shifting from explicit legislative action to a totally different beast. Unlike software copyright, India has absolutely zero dedicated statutes governing domain names or cybersquatting. None. So the entire architecture of domain name protection had to be built from scratch through judicial gap filling. The courts essentially took ordinary trademark passing off principles under the Trademarks Act of 1999 and just stretched them to apply to web addresses. Remember, back in the mid-90s, the internet was this chaotic frontier of dial-up tones and blocky text. The law had to catch up, and it had to catch up fast. Chronologically, this era of judicial evolution is just wild. It starts around 1995, when early domain names like sci-fi were first being registered, moves to the first major high court injunction in 1999, and finally culminates in a definitive Supreme Court ruling in 2004. Let's break down the actual mechanics of those two landmark cases, because they set the stage for everything. First up, the 1999 case of Yahoo Inc. versus Akash Arora at the Delhi High Court. A defendant set up a site called yahooindia.com. Now, at the time, Yahoo had no formal Indian trademark registration yet. But, and here's the brilliant part, the court granted an injunction anyway, using the common law tort of passing off. They basically held that a domain name serves the exact same source identifying function online that a brand name serves offline. The major takeaway? The absence of a physical brick-and-mortar marketplace literally does not diminish trademark protection. If a user types in a URL and is tricked into thinking they're interacting with the original brand, the legal injury is identical to an offline bait and switch. So that high court logic percolated for about 5 years. until the Supreme Court authoritatively settled the debate in the 2004 case of Satcham Infoway Limited versus Sifify Net Solutions. You had two businesses using confusingly similar SIFI domain names. The Supreme Court decisively ruled that domain names possess all the characteristics of a trademark. There aren't just technical web addresses, they indicate a very specific source of origin. This single ruling permanently cemented passing off principles for internet disputes in India. Honestly, it's a true masterclass in common law gap filling working within a codified system. Finally, Section 4, patenting computer-related inventions. All right, we are officially leaving the nicely settled dust of domain disputes and entering an area that is highly complex, hotly contested, and rapidly evolving. Section 3K of the Patents Act strictly outlines what cannot be patented. It excludes a mathematical or business method, or computer program per se, or algorithms. And I want you to focus on that. The entire legal battleground literally rests on those two words, per se, meaning by itself. The law doesn't exclude software-integrated hardware, but defining exactly where unpatentable abstract code ends and a patentable invention begins, that has been an absolute nightmare for patent examiners. And that brings us to the landmark 2019 Delhi High Court ruling Farid Alani versus Union of India. An applicant had been trying to patent a web access method since 1999 and just kept getting rejected. The High Court finally stepped in and logically pointed out, look, in a modern era filled with artificial intelligence and blockchain, treating all software-based inventions as categorically unpatentable would be completely retrograde. Therefore, if an invention demonstrates a technical effect, say making a server run faster, improving memory allocation, or securing a network, it is patentable, even if the instructions to achieve that effect are written entirely in code. It basically shifted the entire focus from, is this software, to, does this software solve a technical problem? And this brilliantly illustrates the absolute administrative scramble that followed. Because the courts mandated this brand new technical effects standard, the Patent Office was forced to constantly evolve its computer-related inventions, or CRI, guidelines. They issued guidelines in 2013, had to radically revise them in 2016, and finalize them yet again in 2017. All just to figure out how patent examiners on the ground should assess whether a line of code is just an abstract idea or if it produces a genuinely patentable technical advancement. You see, unlike domain names, which were essentially put to bed by 2004, the patentability of software remains a genuinely live, breathing doctrinal area. We had the Ericsson case in 2015 acting as a precursor. But then, as recently as 2023, the Delhi High Court in a Microsoft case had to tell the Patent Office again that they cannot reject an application merely because it involves algorithms. And in the Priya Randolph case, also in 2023, this technical effect reasoning was formally extended to blockchain-based inventions. The rules here are literally being written and rewritten before our very eyes. Which leaves us with a absolutely crucial ongoing question. As artificial intelligence advances at breakneck speed, how in the world will this technical effect test evolve to distinguish a functional, patentable invention from a mere algorithmic abstraction? I mean, it's a remarkably fine line between a simple computer program and a complex neural network that essentially thinks for itself. The digital frontier is going to continue stretching our IP laws in ways we are only just beginning to understand. Thank you so much for joining me on this deep dive. Keep questioning, keep learning, and I'll catch you in the next one.